everyone to Pupillage Question and Answer Evening, brought to you all by Law Simplified in collaboration with aspiring barristers. I'm your host and presenter, Farooqi, and I am delighted to welcome our wonderful panel members who have given up their precious time. Thank you so much to each and every one of you. So we have with us today Mary Pryor QC, Queen Counsel and Senior Barrister from the 36th Group. We also have Sahar Farooqi, a senior barrister of up to 10 years called to the bar, previously a director and co-founder at DWF Advocacy. We also have Brad Lewis, called to the bar last year by Gray's Inn, and a pupil barrister at QEB Hollis Whiteman. Now you'll be hearing from our specialists in a moment, who will be asking just to give us a bit of an overview of their journey and to introduce themselves, because I don't think my introduction does any justice to them at all. Now we've had up to, just very quickly, 150 questions come in. And to ensure that we address as many questions as possible and we cover as much surface as possible, what we have done is we have reworded the questions and we've grouped them. No doubt you will all leave today with lots of valuable advice and tips. Just to quickly set the agenda, so as I mentioned, we'll be hearing from our specialists in a moment with their opening comments and a brief overview of their journey to the bar. We'll then proceed on to our main question and answer session, and then end with a quick fire round. Now, our panel members have kindly agreed to stay on for an additional 15 minutes for the quick fire round at the end. So I'd be so grateful, I would be grateful if you would all stay on for an additional 15 minutes as well, so we can address any questions that we don't manage to during the main session. Now, lastly, just a few housekeeping rules. Please make sure that your microphone and camera is turned off throughout to ensure we have no disruptions. We've had some more people just join on if I admit them into the session. So I'm going to hand over to our specialists. Mary, if I could please start with you. If you would give us a bit of an overview of your journey to the bar and share any opening comments that you might have for us.
Well, good evening, everybody, and well done for joining this session, particularly in circumstances where it's difficult to remain motivated as a student, not only because of the absence of human contact, but also because you all know it's becoming more and more difficult to get a pupillage. But taking part in events like this shows and demonstrates determination. And that's really the difference between success and failure in a career at the bar. I think everyone who succeeds is stubborn. My journey to the bar is a long one because, as you can see, I'm quite an old human being. And let's see, I grew up in a council house. I had free school meals, free school uniform, spent most of my life being looked down on because I had a very strong northern accent and none of the social skills of those other people in my class who had the same intellectual ability as me, but also so much more privilege because they knew things that I didn't even understand, I didn't know, like how many knives and forks to use and just basic social skills. I went to a polytechnic. I didn't go to university. I worked 2 jobs throughout it. My dad died in the 2nd year of my degree. After that, I got a job in industry for a year. Then I worked as a magistrate's court clerk. Then I joined the Crown Prosecution Service because it was a place that gave you a sponsored pupillage. And at the time I did pupillage, you had to pay to do it and also pay for your living expenses, which someone from my background just couldn't do. And then with a 2-year-old, a 1-year-old and a baby, I was offered early redundancy from the Crown Prosecution Service. I took it. I applied to, I think, every set of chambers in the country and got rejected by all of them except for one, a very small set in Wolverhampton. They gave me a chance. I took it. I worked really hard and then I got headhunted into the 36 Group. I'm now a Queen's Counsel. I'm a Tier 1 leading silk in criminal law. I am a part-time judge, so I sit as a recorder in the Crown Court and the Family Court, and I'm Woman of the Year. Get me, eh? So a long and rather convoluted journey. But the reason that I like to share it with people is because I genuinely believe that if I can do it, you can do it. And what's my magic formula? I'm not the brightest person in the world. I certainly didn't get it on my looks. And I certainly didn't get it because I knew people in the profession. I knew no one. But what I had, which I think your other two panelists you'll see have in droves, is determination, or stubbornness, as I like to call it. So that's my journey, Farooqi.
Thank you so much, Mary. And I'm sure you'll see all the comments coming in. What an inspiration to us all. Thank you, Mary. Can I now please move on to Sahar? Sahar, if you will do the same for us, please.
Hi, well, good evening, guys. That's a tough act to follow. I certainly can't claim to be Woman of the Year. Not much has happened this year, really, for me in terms of awards. I suppose I may still get one for Weight Gain of the Year, but that may be something that several of us can share. As far as my journey is concerned, it's actually something which is far less exciting. It's quite linear, probably what many people expect. I, by contrast, had quite a privileged upbringing. Although I'm the child of immigrants, my father came to this country in 1968. He worked very hard, and he made the decision to spend the money that he earned, and with the support of my mother, send us to private schools. So I had that opportunity, and then I went to Bristol University from there. From Bristol, I went and did the bar immediately because I was pretty much fixated with the idea of being a barrister from the get-go. From bar school, that was the moment at which I kind of began to experience what Mary was talking about then, and have to really begin to hone resilience and tenacity as a skill, because that's the moment at which I began to really experience proper rejection for the first time. And it becomes something that you just get used to, and your skin gradually gets thicker and thicker because it's part of the process. What I'm describing now is about 10, 12 years ago. And since then, the situation, I think, has pretty much stayed the same. Some would probably suggest it's got slightly worse. But overall, from that kind of position, which people, as I say, would be fairly used to as an idea from university onto bar school, I had some time after those rejections to begin looking at my overall candidacy, looking at how I am presenting and where my weaknesses are. And there are still many weaknesses, of course, but there's also an opportunity during that period post-rejection to learn. And that's one of the key messages that I think everyone will tell you over and over again, that those rejections are something you will encounter. It's unfortunate, it hurts, but the real tragedy of a rejection is if you don't learn from it. There will almost always be something that you can take away from the experience. And if you do that, after one rejection, two rejection, 10 rejections, 100 rejections, you're much better off for it. From there, I went into actually a criminal pupillage, largely at a prosecution set. I practiced in crime for a couple of years, decided that I wanted to diversify my practice for reasons which I'll explain later on. And through general civil, I actually left self-employment and the self-employed bar, went into employment, doing general civil work, and ultimately doing what I do now, which is commercial litigation and international arbitration. So it's been a slightly weird journey, which has taken me in practice from self-employment and crime to now employment and commercial. More on that later, and more on the employed bar later, but that's probably enough at this point.
Thank you so much for that, Sahar. Again, a very inspirational journey for us all. Brad, please may I ask you also to share any opening comments and give us a snapshot of your journey, particularly touching on your pupillage, which you're currently undertaking. Thank you.
So before I start, I know I'm speaking for all the panelists here, I'm sure, but I just want to say thank you very much for organising this, Farooqi, and to Law Simplified. I think it's an absolutely fantastic way to kind of take advantage of the situation that we're in right now. I know that I didn't have this when I was applying for pupillage or anything kind of near to this, where I could hear from a range of panelists. So it's a fantastic opportunity, and whatever you guys that are listening can pick up from this and take that away will be a benefit, I'm absolutely sure. So as said, my name's Brad. I'm a pupil at QEB Hollis Whiteman, which is a criminal set at heart. It does other things as well. I think we do a bit of public law, inquest inquiries, we do a bit of regulation, discipline, and we do recently a bit of defamation and other things. Like all criminal barristers sets, it's diversifying itself to adapt to the situation that we're in. But to take it a step back and look at my trajectory towards the bar, I think I set my eyes on being a barrister when I was about 16 years old at school, because I was good at essay-based subjects and I loved an argument and I loved kind of writing my opinion down on essays and on books and things like that. And it developed from there. I applied to go to university. I was a bit unsure about whether I would make it to the bar because of my background. I went from, as you can see, I'm from an ethnic background. My parents are mixed race. My mum's Italian, my dad's Jamaican. I went to a state school. I grew up in a single parented household from very modest means. We were quite poor for a while. And as you can maybe tell from my accent, I'm northern-ish. I'm from a little town just between Derby and Nottingham. So that's kind of ethnic, northern-ish and poor. I saw as the trifecta of not fitting in at the bar or within the legal profession. So I went forth with a bit of caution to study law, with my eyes wide open and having been told multiple times that I wouldn't make it, that it's a profession that's beyond my means, my background. And I studied law at the University of Liverpool. I did okay in my A-levels. I actually did one of the best in my school, but I didn't get straight A's or A stars, as many law students will do. And so I wasn't super confident in my own intellect until I got to university, and I found myself having a natural affinity to law. I did my LLB at the University of Liverpool, and in first year I started doing really well. I came out of university with a first class degree, and I thought I wasn't quite done with studies yet. And this was partway through my third year. I decided to apply for an LLM, which I did. I applied and got a full scholarship to Cambridge, where I did a year-long LLM funded by my college, that was as in the constituent college for Cambridge, not my old sixth form college. I came out of that, I graduated from that, and I got a bar scholarship from Gray's Inn, and I did the bar course at BPP in London. I also got a residential scholarship from Gray's, which is a great opportunity. If there's anyone that's sort of not quite at bar stage yet, have a look at that. It means that you can go and live in the inn for a year whilst you're doing your bar course. That's something to look at. So I did that. I lived in Gray's Inn and I studied at BPP. I came out of the bar course and was lucky enough to get pupillage first time. I'll talk a little bit later about how many sets I applied for and things like that, because I know there are specific questions about that and what applications are like. But yeah, I always had my eyes set on criminal law. I swerved for a bit when I was an undergrad. I did internships at an investment bank and at a commercial firm. But I came back to criminal law because that's just what I was really interested in. And I thought, if I'm going to be a barrister, I'm going to be a lawyer, that's what I want to do. even if it's going to be hard, even if the sort of naysayers are saying that the criminal bar is a very hard place to make a career right now, I'm going to do it anyway. And as I say, I was lucky enough to get pupillage at QB Hollis Whiteman, where I am now 3 months in. And so I'm in my first 6, I'm not practicing, I'm just assisting on work and writing advices and things like that. And we can chat about that later. And that's where I'm at.
Thank you so much for that, Brad. Again, as mentioned, for all our other panel members, a very inspirational story for us all, and one that we can all relate to. Thank you. So I think we'll crack on with the main question and answer session. As mentioned, we've had a lot of questions, but we have grouped them and reworded them as broadly as possible so we can cover as much surface as possible. The very first question I have, Mary, if you would start us off, please. How should candidates demonstrate an interest in certain chambers or legal practice areas in the absence of any mini pupillage or other legal experiences, assuming that they've tried to get that experience?
I think a lot of people have been asking this question, Fahim, on many different medium. And it's a really important question. You can't get mini pupillages at the moment for the most part because of social distancing and limited space in courtrooms. And so as a trainee lawyer, you need to start using one of the skills that you will use in your everyday life, which is seeing obstacles as opportunities. And doing things like this, being part of this session, running sessions like this, organising these events, demonstrates a real interest in the profession. Try and understand, if you can, that almost everyone who applies for pupillage or any type of scholarship has the necessary qualifications to obtain pupillage or that scholarship, because chambers weed out those that don't meet the criteria. So if you've got to the stage of getting an interview, you meet the criteria. But where people struggle is precisely this question, demonstrating an actual interest in the profession. So there are 2 aspects to this question. One is demonstrating interest in the profession, and the second is demonstrating interest in chambers. Let me deal with demonstrating an interest in the profession first. You can moot online. There are lots of moots, and Fahim, if you are able, I would love you to organise as many moots as you can for candidates, and I'm sure the 3 people on this panel would more than happily judge those for you again and again, because getting a law degree is the equivalent of learning the highway code without ever having got into a car. And what mooting teaches you effectively is how to drive. So you know the theory, and what you need to do is to practice. And as people who sit on panels for both scholarships and interviews, what we want to know is whether you are actually interested or can demonstrate an interest in speaking, in doing oral advocacy, because that's what you're going to need far more than following people around. Following people around is, well, it can be just like collecting Blue Peter badges. You can say, I've got 6 mini pupillages, I've done 6 mini pupillages, but actually you haven't done anything in them. You haven't done any written work. You haven't practiced an advocacy skill. You've simply shadowed. And that's a useful thing to do, but it's not necessary to have lots of them like badges. What chambers are actually interested in is what you have learned from any process. So I think mooting is vitally important. I think you should go online and find free lectures on subjects that are actually part of your interest, but also those that extend beyond it. So for example, at the moment, Harvard, at Yale and the Open University are doing free lectures on subjects which touch on your degree or your BPTC course, but may not be directly on it. So you can get courses on forensic science, for example, forensic access, do free science courses. And you would want to put down, I have been to a series of lectures on forensic science, forensic medicine, on civil procedure, on the changes on this, that and the other. All these things are free. So you're not doing anything else in the evening, I imagine, after a day's studying. Put these things on and listen to them. Expand your brain where you can. So mooting, lectures, write, if you'd like to, an article. If you don't have time to write an article, go on to LinkedIn, which is a very useful place to connect. See what someone has written as a post and write something back. Write something about the article you've read. Write a question about the article you've read and gain contacts, gain a network. Because if you don't have a network of lawyers, and most ordinary people don't, that's a great way of doing so. The other thing you can do is to follow the news. Follow legal news. If you put legal news into your Google website, it will come up with all the new things that have happened in law. Show that you've kept up to date. Perhaps write articles for Legal Cheek or Law Weekly, or write an article yourself on LinkedIn. Or do what I've suggested other students who are in fact part of this event this evening do, which is run moots yourself. So if your university isn't running them, set them up yourself. Set up advocacy competitions. All those sorts of things show an interest in law, far more in fact than a mini pupillage does. Now, in relation to showing an interest in chambers, that's more tricky, particularly without the opportunity of going in. But here are my sneaky top tips for that. Firstly, Google. If you are interested in a set of chambers, Google them on a regular basis before you have an interview or before you apply, and see what's coming up. Look at their website. See the faces on that website. Is there anyone who looks anything like you? Is this a chambers who are properly interested in diversity, equality and fairness? Or are you going to be the first person of colour? Are you going to be the first disabled person in that set? That mustn't put you off altogether, because if you want to go to that set particularly, then you can express to them why you should be the first. But if you want to be part of a set that's properly forward thinking and which is going to assist and progress, have a look how many women have made silk in that set. You can have a look at a set of chambers in Birmingham at the moment, which has about 140 members and no female Queen's Counsels, none. Now, that doesn't mean that's always going to be the case, but actions speak louder than words. So have a look in a set of chambers at who is there, where those people come from. You can look at people's educational background. If everyone in that set is from Oxford or has gone to Oxford, and you're not at Oxford, it may not be that they're going to take anyone who isn't. There are sets, sadly, and I think it should be something that stops, but there are sets, sadly, that don't take anyone except someone who comes from Oxford. Have a look also at where they work geographically, because just because a set's in London, for example, doesn't mean they have any work in London. They may be constantly working in the southeast or the southwest. Have a look at the sort of work they do. Also, have a look at whether this is a set that is putting out a message of outreach, inclusivity. Because if that's something that matters to you, then either you are going to be in a set where you're fitted with that, or it's something you're going to have to suggest to them. But what you need to find when you are researching a set of chambers is who's there, what do they do, have a look at the cases that are on people's lists of cases, read them if necessary. Read what the silks are doing, but importantly and particularly, look at the page that deals with pupils. See how many pupils are taken on at the end of their pupillage, what they're doing, how they're supported. And if you wanted to, and it's a set you're thinking of applying to, you can reach out to those people on LinkedIn and say, I'm considering applying to your set. Can you tell me what pupillage has been like? Remember, any interview is a two-way process. You are applying to them, but they also have to demonstrate to you that it's the right place to go. And certainly so far as my set is concerned, if we take on a pupil for pupillage, we expect them to be staying. So make sure that you're applying to somewhere like that, not somewhere where half or 2/3 of the pupils are then just sort of got rid of at the end of pupillage and sent over somewhere else. If you kind of think of it this way, and I know it sounds a little bit weird, but gaining pupillage is a bit like winning the lottery. Because once you have done your pupillage, you can work anywhere in the country and you can make a good living. So you need to invest within it all of the work that you would do if you were willing to win the lottery. So research, take care, and make sure that you've done your research before you make an application or before interview.
Thank you so much for that, Mary. That's very comprehensive. Thank you. Sahar, so I have a question for you, please. So some have been unable to obtain legal work experience or in-person mini pupillages, either due to personal circumstances or due to the pandemic. A, would that be disadvantageous to them? And B, how can they still show a dedication to the profession? I think Mary touched on quite a bit there, but do you have any thoughts on that too, please?
Yeah, just before that, to underscore what Mary said there on a practical level, that was something that you could easily infer from what she said. Chambers will have handbooks that they've published, which they're required to publish for pupillage. I know because in the last couple of years in particular, I've authored one myself as well for a provider. So in circumstances where at the moment you're not able to do mini pupillages, and there are still a few out there, virtual mini pupillages, but in circumstances where you aren't able, you can through LinkedIn approach people, as Mary said, and ask them about the culture and ethos of Chambers. But the handbook and the website should also give you something of a flavour. It should tell you, for all the reasons that Mary's identified, but also explicitly what they say about themselves. That should give you some insight. Coming to the question that Farooqi has just asked, I think the answer is that 2020 has been pretty uniform in its impact across the board. COVID, obviously, not just the year itself. So Chambers, providers, everybody understands that impact. All of you have been affected in a way which members of a pupillage panel will understand, and they will remember in years to come as well. It's obviously not even over, looking at the news in the last couple of weeks. So I understand why it's a concern, but try and draw some solace from the fact that everybody has been impacted in the same way. Mini pupillages are just harder to come by, and that's something that's understood. So in terms of how you can still show your dedication and interest in the professional or law generally, I think Farooqi's right. Mary's touched on a lot of that in her answer, so I don't want to cover the same ground. But just remember that you can always look for other opportunities to show your interest and dedication. Yes, being here tonight is a good thing. Organising them is an even better thing. But there are still things you can be doing, things that many of you will be doing, pro bono activities, through mooting, debating. Debating is obviously an important one. You can organise those amongst yourselves in the same way you can organise a moot. Legal writing, again, Mary touched on that. One thing which hasn't been touched on, it made me smile slightly that all three members of the panel are from Gray's Inn. That's because Gray's is the best inn, and there is no way that anyone will ever convince me otherwise. I'm being slightly flippant with that because I'm told there are 3 other Inns of Court as well that you can join, but there's no reason to. Anyone who is from Gray's Inn will tell you that, because we're incredibly proud of the inn, but it's the smallest inn and it's a friendly inn. And as a result of that, I found certainly on my journey that when I joined the inn, the education department was infinitely more accessible than my peers were telling me about at other inns. Now, the education department at any inn, I imagine, is probably based on the same principle, which is a principle that's true of life in my experience. You'll get out of it what you put in. If you ignore them and you don't engage with them, they're not really likely to be of any use to you. But if you engage with them, if you get to know them, then they will help you. That's what they're there to do. They're there. It's an 800-year-old institution that exists to educate barristers. They have connections that are far greater than all of us combined. They have resources that are far greater than all of us combined. And they have a knowledge base which is greater than all of us combined. So joining an inn is a necessary thing for you to do if you want to be a barrister, but it's also a fantastic opportunity to develop your network and gain insights and opportunities to meet other barristers and to be exposed to opportunities. Don't underestimate that and don't dismiss it, because it's something which has existed, as I say, for so many years and is there for that purpose. Similarly, and it's obvious, but things like paid work, even VAC schemes or paralegaling, those are opportunities for you to, if you can get them, if you're lucky enough to be able to get them, to develop your CV and your knowledge base, which is also obviously important as you're looking to develop your application overall. So I think that's probably the points I'd make in relation to that question.
Thank you so much for that, Sahar. Can I mention I'm part of Lincoln's Inn? I don't know if I should say that at this moment in time. Thank you very much for that, Sahar. I'm now going to move on.
None of us perfect, Fareen.
Brad, so please would you name some extracurricular activities which you think applicants can undertake to put them in a good stead for pupillage? And again, bearing in mind the current climate.
In fact, if it's okay with you, I think I've got a quick answer to Ricardo's question, and then I'm going to move on to that, or one of Ricardo's questions. Work as a paralegal. I paralegaled per se. We were called Crown Court caseworkers, but I paralegaled for a year in a firm in the Midlands called the Johnson Partnership, and I worked as a police station representative for them as well, so doing police interviews. I honestly couldn't tell you how valuable the experience is to pupillage. The transition that you get from bar school to paralegal into pupillage is so much smoother if you do paralegal in the practice area that you're going to go into than otherwise. It's a big jump from bar school to pupillage, learning things like digital case systems, how to read a case, how to interact with clients and things like that. All stuff that hopefully if you go to a good firm that look after you and that invest in your training will make you do during your time paralegaling, whether that's because you don't get pupillage this time round and you have to reapply next year and so you've got a year there, or whether you have what we call the enforced gap year, where you get pupillage but you have nothing to do for a year, which is what happened to me. So I paralegaled for a year. So that's one of your questions, Ricardo. I'm sure we can come to the rest in a minute. But for you were asking the question was about legal experience in light of the current climate. What can be done? And my kind of headline for everybody is to be innovative. And I know Mary's touched on this earlier in a couple of points that she was making, but when I saw this question, I had to think about, well, what am I doing now that's perhaps CV enhancing, if you were to look at it like that I would be putting down if I was applying for pupillage this year. So separately to virtual mini pupillages, which we know are few and far between, they're out there, so if you can get them, do them. But voluntary work, as in remote voluntary work, be innovative as to what is there. So this year, I've been volunteering with a project called the American Exchange Project, AEP, which it's a charity that's been set up by a friend that I went to university with. He's American, and it works to combat polarization in America, so specifically with American school students, by creating networks of American students from very different backgrounds. So from very affluent backgrounds in Boston to very rural and simple farming backgrounds in Texas. And he creates Zoom chats and talks and things like that, and invites guests on who have, so he says, interesting stories to talk to the students sometimes and to have a conversation. Get involved with something like that. If there's anything out there that might not seem, and this is where what I mean by be innovative, it's not the logical step, but there are so many things that you gain from doing stuff like that that you can talk about in a pupillage interview and that you can write about in an application. Another one is taking or using the time to learn something, specifically if there is something that relates to your intended practice areas or potential practice areas. So a language is always helpful. Coding, if you're into something like that. Trading, if you're looking at going into financial law or corporate law, that kind of thing. And what I mean by relating to your practice area is, if your client, when you become barristers, if they're dealing with something that when they're doing whatever it is that you come in to help with, for example, trading, it helps infinitely for you to understand what the life of a trade is like, what that looks like, who are the parties that are getting involved, what are the considerations, what are the risks, that sort of thing. So great time to learn stuff like that, that a lot of barristers don't learn until they come to the point of having a case where that becomes an issue, and then they have to learn it sort of on the hoof. And another one is remote tutoring. So up until recently, I think up until I started my pupillage, I was a tutor at Bloomsbury Law Tutors. There are always students looking for tutors, and that can be anything from school studies to university studies to applications, things like that. It's also the potential to earn some money if that's something that you want to do. But yeah, and it helps refine your knowledge on areas of law that you might go into practice and you might not. And it helps you generally in terms of oral advocacy skills. I think thinking about what's the most sensible and easy to understand way of presenting what can be quite complex areas of law to someone that most of the time have struggled to understand it in the way that they've been taught it. I can't stress that enough, how helpful that was for me. So those are all examples of all things that you can be doing even during coronavirus restrictions.
Thank you so much for that, Brad. That was really helpful. Thank you. Mary, we're now moving on to how do I choose from so many chambers? Now, I have a question here. What is the best advice you would give to someone when choosing their favourite chambers, and what factors should they consider?
Well, if you have the luxury of deciding on your favourite chambers to accept pupillage in, then you're in a marvellous position. And there are some people who have the option of 2 or 3 places to choose from at the end of the round of pupillage. But I suspect what the question is actually getting at is, which chambers do I apply to? And that again is part of doing research. So the first thing you need to ask is, where do I want to work? Where in the country do I want to work? And there may be good personal or social reasons why you should be working in a particular geographical area. So you can limit to a large extent where you are going to apply, depending upon where you want to work in the UK. There's no good, for example, living in Carlisle in the far northeast of the country and applying to a set of chambers in Plymouth just because you can, because the set of chambers in Plymouth will know that you're not going to stay. And it's a huge investment for any set of chambers to pay for pupillage. The money for pupillage comes out of the individual members of chambers' money. We have to pay out of our own money for the next generation. So chambers as a whole are only going to really want to pay for people who they think are going to stay. So try if you can to have some geographical connection to the place that you wish to go. Now that can either be that that's where you live, or it can be that's where you've been at university and you have settled for a number of years, or any other reason, but that would be the first thing. Secondly, you need to have a look at the things I've already mentioned to you in my previous answer about whether the pupils are taken on, what the sort of work they do is, and what the ethos of that set is. Also have a look, really, I think, at your prospects of success in a set like that. As I said, if everyone there has gone to Oxford and you haven't, then you might be the first person they take on who hasn't. If you read the blurb in their website that says, we are really now seeking diversity. But if it doesn't, and it says we pride ourselves that, you know, we only take on the very highest caliber people or whatever, then that's one of a number of pupillage applications that you're going to make, because you can only make so many, as I understand it, that is unlikely to succeed. So see where you feel that you would fit in, see geographically where you could go, and then have a look at what those chambers do. Because if your interest has always been family law and you're applying to a set that just does the law of transport or shipping, it's going to be pretty obvious by the time you do your application that you've shown no interest thus far in that area. So look for sets that have got a particular area, even if it's a mixed set, and draw up a list and then reduce them down. Because like everything else, unless you've been to that set, you can't really know. So you have to do research and put them in an order. So I'd really like particularly to go to this set, and here are my other 9, or here are my other 11, whichever it is now. And once you've done that, then fix on those. But what you mustn't do is just a scattergun approach where you make the same application to all of these sets, because it will be obvious that that's what you've done and you will be unlikely to succeed. Your application must in each time be tailored to the place that you're applying to. I hope that helps.
It has, thank you so much. Sahar, I'm so sorry, I lost you for a second there. I have a question for you. I think, again, it's probably an add-on from what Mary's mentioned already, but I've had a specific question here. Can applicants say that the chambers in their geographic location are not so good to justify applying to the London Bar? In this particular case, we had Kent. What would you have to say on that?
Well, there's a couple of things. Maybe the panel have a different view on this, but London is not generally subject to the regional approach, the approach that's taken in the regions. That is to say that, in my experience, London sets don't tend to look for a commitment to the local geography in the way that regional sets tend to, because it's the capital city. People tend to understand and accept that a move to London, rightly or wrongly, if that's required by the applicant, is something that they would probably be willing to do or want to do, because everyone wants to live in London, apparently. Whether or not you agree with that, as I say, it may be that Mary or Brad disagree, but beyond that, personally, I don't think saying that the local sets are not good enough for you is a sensible approach. You don't need to go negative. You're not Donald Trump. You don't need to start making those sorts of suggestions across the board. Really, all you need to be talking about is if you are approaching that situation where geography is something that you need to be able to express some kind of proximity to. So if you're looking at a set in Bristol, for example, or a set in Birmingham, or a set in Leeds, some sets in those cities do expect candidates to have some kind of link to the city or to the locality, at least the geographical area. And to do that, people demonstrate their links by where they studied, by family links. Be careful with that, though, because there are all sorts of stories about people saying that their grandparents are from Birmingham and then not being able to name where they're actually from. That's obviously pointless, so keep it truthful. But I think that's the way in which to approach it. You don't need to go negative. And I've never heard of anyone saying, why didn't you apply somewhere closer to you? That I think would strike me as a slightly odd question. Mary, I don't know if you have any strong views on that.
I have strong views on the fact that I think anyone who believes that regional sets are not as good as London sets, well, they're wrong. There are many massive sets of chambers across the country who do phenomenal work in all areas of law and are highly renowned. Just thinking about Birmingham, Manchester, Newcastle, they are large and vibrant legal communities. So if you were to say in any interview for a set of London chambers, well, I can't apply in the Northeast because those sets are not as renowned as sets in London, you would probably fail for two reasons. Firstly, because you haven't done any research into what the Northeast has to offer. And secondly, because I don't think people would take the view that that was serious. I mean, there are the occasional niche area is different. So, for example, I think shipping law has limited regional availability in terms of sets of chambers. But aside from that, if you're doing commercial, civil, criminal, family law, you can have equally as busy and successful a career in the regions as you can in London. My chambers are in London, but I don't work in London. I've spent almost all my practice in life working in the East Midlands, and I'm a Queen's Counsel, so it's never stopped me.
Thank you so much for that, Mary, and thank you, Sahar. So Brad, final question in this category. We have, should applicants name drop barristers who they've worked with before or whose articles they've read when applying to their chambers?
I think that this is a question where it's actually quite hard to give a definite answer without knowing the context. But my main advice is, if you're going to do it, be careful about it and be tasteful with it. Don't just sort of do it willy-nilly to make you sound better or more well connected than perhaps you think you are, because it can come across the wrong way sometimes. You can do it genuinely. Don't get me wrong. And when I say genuinely, I don't mean genuinely name drop. I mean genuinely talk about members of chambers and their work, which is linked with your interest or work. For example, a direct example that I can give you. So I was applying to Carmelite when I was doing my pupillage applications, and at the time they had a tenant called Felicity Jerry QC, who was very, very heavily involved with joint enterprise and the Jogi case that sort of brought the end to joint enterprise, so-called joint enterprise liability in the UK. And she's been an active advocate against it in various different jurisdictions. She's wrote numerous articles about it, etc., etc. You get the point. I spoke about using her work in my dissertation and in my research, which was on joint enterprise liability in light of Jogi. So that's it. That's kind of that's so close as you can get to a genuine name drop, in that I was saying, look, I'm interested in these chambers because you have advocates that do this, and I'm genuinely interested in this, as I can provide examples for, which are this. So you see the point. If you've done minis, then I think if there's scope for it, if you've got the word count, etc., it's always good to say who you did the mini with. If you made a good impression, that is, that's a very, very strong caveat. Don't say I did a mini with this person, then they're not going to give you a good sort of reference in a way. But if you went along, you got along well with them, and maybe you did something and they gave you some good feedback or something like that, it's always good to say that, because I know for a fact that my chambers, if you say I did a meeting with this person, they will go and talk to that person and say, what did you think of them at some stage in applying for pupillage? I don't know. I'm sure it varies from chambers to chambers as to whether they do that, and if they do that, when, whether it's on the paper sift or after, but always a good idea.
Thank you. Sahar, do you have any thoughts on this?
Yeah, it's a pretty comprehensive answer. I think I'd just add, don't become sycophantic. It comes across particularly in interview. You have to understand that there may be half a dozen people interviewing you, sometimes more, frequently less than that, but you don't want to talk about people to the point where others in the room start thinking, all right, well, why don't you know what I do? Why are you so obsessed with her or him? It's something that's useful, and if they ask you about it, then you need to be prepared to actually talk about it. Don't name drop without actually having done the research. Don't say, you know, I think Mary Pryor QC is really inspirational, and then someone says, well, what can you actually tell me about her background? And then you say, oh, not much. That's pointless. So don't be sycophantic, and if you are going to do it, then make sure you know the people properly.
Thank you so much for that, Sahar. So we're now moving on to the next section, which is about, the questions are about, legal practice areas. So Mary, if I can come back to you, please. I had a few candidates actually ask this question. If a candidate is interested in a single area of law, should they only apply to the chambers specialising in it, or should they broaden their interests?
Well, I think the starting point is to look at where the opportunities are at the moment, because lots of chambers have withdrawn their this round of pupillage. So if you are looking at pupillage providers for the next 12 months, then you need to look at what's on offer. If there are chambers having gone through the process we've already described of analysing where you want to be, that are offering the area of law that you are most interested in, then obviously you should apply to those first, because you are most likely to succeed, because you'll find it much easier to demonstrate your interest in a particular area of law. But if they are not there, or if there are insufficient of them, then you would need to broaden your horizons, because at the end of the day, what you want is a pupillage. And often people start off being interested in a particular aspect of law, and as their pupillage or practice develops, they change. And they change because most sets are not just single practice areas. And so you get offered other opportunities. So you might start off, for example, being fascinated by and thrilled with the interest of jury trials, and suddenly find that actually what you're really interested in is a paperwork practice doing a particular aspect of regulatory work, which just happens to dovetail with criminal law. So in those circumstances, you will need to adapt your application to show your interest in that area, which you may have to do pretty quickly. But I think the thing to do is to apply. Firstly, apply to those that you are most interested in, and then apply to others using the skills you have to make the applications. Everybody just needs an opportunity.
Thank you, Mary. Any thoughts, Sahar or Brad, please?
I'll let Brad answer that. Just one thing I've just said in the chat box. If you're asking questions, please don't message them directly to me. Paste them in the group, because the other panelists may have a view as well. They may have a more informed view. In fact, they almost certainly will. So can you post those questions publicly, and then we'll address them together. Sorry, Brad.
That's absolutely okay. So sorry, I was answering one of these private questions.
Okay.
The question was on if a candidate's interested in a single area of law, should they apply to the chamber specialising in it? Should they broaden their interests?
Yes.
I think, I mean, I'm sure I'm touching on ground that's already been covered, but I'm trying to cast my mind back to what I did, and I definitely diversified myself and my interests a bit. but because of necessity, that was a large factor in the, I was fully, as I've spoken about before, I was fully aware that the criminal bar has come into quite difficult times, and there are a lot of barristers, particularly at the junior end, that are diversifying their practice so as to make sure that they earn enough to carry on working as barristers. And so when I was applying, I was very focused on not just applying to legal aid and criminal sets, because I knew that they could struggle in times that were in the sort of very near future. And I did apply to places that weren't just crime as well, because I had interests elsewhere. I had interest in family law in particular, and a little bit in public law. So I applied there, and I just made it clear in my applications that my primary interest is crime. And I think if you're honest, a lot of chambers will be quite happy to hear that, in that there are so many mixed sets out there. There's very few sets that actually specialize in just one thing, if any. And if you say, I'm coming to here, I'm happy to learn about this, this, and this. I've got experience in this, this, and this, but my main focus wants to be this. That's something that I think is quite refreshing to hear for chambers, because they know whether you're going to slot in well, they know whether they've got that kind of work there. And it's a conversation that you have at the start of pupillage as well, in that my pupil supervisor sat me down and said, well, what areas of practice in chambers are you interested in? And I will set you up so that you can see them. So just be honest with me now. If you don't want to do financial crime, tell me that. So yeah.
Thank you so much for that, Brad. We're going to now move on to Sahar, please. It's a question about scholarships. I can see quite a lot of private messages coming in for me as well. Please, again, as Sahar has said, if you would put them on the group chat, I think it would be good for our panelists to be able to see them. And if they're able to answer, I'm sure they will. Sahar, I've had quite a lot of questions actually about scholarships. How do chambers perceive applicants who have failed to secure a scholarship with their Inn of Courts or the institution with whom they're studying the BPTC? Are they at a disadvantage?
Oh, well, I'll start with a slight segue on this, which is just to say I never applied for a scholarship when I was doing the bar course, or just before I did the bar course. And to date, that remains the biggest regret of my years of study. I don't know why, but I convinced myself I just didn't stand a chance. That's one of the reasons why I regret it, because you lose nothing from applying. Different inns take a different approach to scholarships, and I'm not saying you're guaranteed to get one, but the reality is that it's an opportunity to experience an interview scenario, which at that point very few people have meaningful experience of. And more than that, it's an opportunity to gain funding and to have something on your CV that will potentially help you, which brings us back to the thrust of the actual question, and really about whether or not it's something that will disadvantage you. This is something that will vary chambers to chambers. You've got to understand that every chambers will have their own mark scheme. That's why they also have different questions, because some sets are looking at things differently. I suspect, though, as a general point, taking it in the round, that there will be marks available on most chambers' mark schemes for scholarships. I've sat on a number of pupillage panels. I'm a pupil supervisor myself, and as of this year as well, I'm sitting on the subcommittee of Gray's Inn's scholarships. So in light of all of that, believe me when I tell you that despite sitting on all those panels, I've never heard anybody say after an interview, well, she has a named scholarship, but he doesn't, or she has a better scholarship than she does. That conversation doesn't happen. It's something that you're afforded marks for, probably on the mark scheme, and then that will be it. Once you've crossed the threshold, to interview, it's not something that really ever comes up again in my experience. So if you're sat there and trying to put yourself in the shoes of the panel, all it tells us is that your in believes, based on your performance on through an application process, that you present as somebody who has prospects to forge a career as a barrister. It doesn't automatically mean that you should get pupillage, and many people who get scholarships don't get pupillage. So beyond those marks that you get when they actually mark the script, I don't think it's something that will disadvantage you. Again, in the round, I think it helps. It's something that's positive, of course, but it's not a massive issue if you haven't got one, and it's certainly not fatal.
Thank you so much for that, Sahar. Mary, can I ask you if you had any thoughts on that question as well, please?
I think the first thing I would say is that a lot of people don't get a scholarship because they don't apply for a scholarship. They automatically write themselves off before the scholarship process even begins, thinking, well, I won't get one. Grays in particular have a wide range of scholarships for a wide range of people, and some of those involve considerable amounts of money that we will invest in people who we think have prospects. But once you're on your feet as a barrister, there's no judge who's going to say to you, do you have a scholarship? And certainly in the pupillage application process, there are only so many marks that you get for academic ability, which is where this would fit in. And you can only gain so many marks. So let's say it's 30 and you have a first class degree and an outstanding on the BPTC, you've reached your 30 marks. Also, I interview for scholarships on a regular basis. And I can tell you that the distinction between those who get a scholarship and those who don't on occasions, it can be something like 1 or 2 marks, because there are a limit to the number of scholarships we can give. And all those who are interviewed for a scholarship have reached a standard where we take the view that they could easily get a scholarship. And the difference is often just on the interview. So I think the fact that you have been interviewed for a scholarship is as important in many ways as the fact that you've got one. But I don't think it's life or death. I don't think, certainly lots and lots of people who have very successful careers at the bar and who've got pupillage did not get a scholarship.
But I think if I could just add, that said, apply. I can't stress that enough. I don't know if there's anyone here that's not done the bar course yet, but if you if you haven't, apply. It was the difference for me to becoming a barrister versus not. I had no way of conjuring up £19,000 plus living expenses to the bar course, and you have nothing to lose. And do your research if as to what you want to apply for scholarships for, because they vary in terms of what amount is offered and how many scholarships are offered. And I looked really in depth at it because I knew that it was such a defining factor for me. If you haven't and you're able to do the bar course anyway, then fair enough.
Thank you so much for that, Brad. We're now going to move on to the next set of questions, which are about academic performance and professional work experience. So Brad, a number of questions again, I think particularly about non-legal work experience. So should candidates be selective when putting down their non-legal work experience to make sure they include only those roles which evidences the skill sets relevant to the bar profession?
Well, I don't think, I'm going to answer this in a roundabout way, but there's so much value to your non-legal work experiences that a lot of people don't recognize. And even myself, I didn't recognize until sort of right close to applying for pupillage, things that I'd just omitted from my CV because I thought that might devalue my application, things like that. Like, for example, I was a waiter for about 7 years of my life, part-time, throughout the whole of from A levels right until applying for right until bar school, I think, slash waiter slash retail assistant or whatever. And there's so much to that that you can sell in your application. For example, you work as a waiter, you work in a busy environment, you deal with people and their everyday problems day in, day out. You have a position of trust if you count up money and responsibility, and you balance that alongside the demands and the rigors of your academics and your bar studies and etc., or your childcare commitments. Is everything okay?
Yeah, sorry, I think we had someone just join just now.
All right.
Yes, all muted. Continue, thank you.
So yeah, put them down, and what I found really helpful when I was sort of putting together my pupillage applications is I put down every experience, including non-legal work experiences, and then I drew up from the internet a list of competencies for barristers, and they're very accessible. I think I got it off an IN website. I think it might have been Lincoln's or Inner, but I then had a look through each of those competencies and thought about every non-legal work experience that I'd done, and thought, well, what barrister competency does each of those show? And I created a spreadsheet, and I made sure that for every non-legal and legal piece of work experience, I had a competency and an example from that experience to demonstrate that competency, like I've just done with you guys in terms of waiting tables. And it's really important. And I can't tell you how much I was asked about part-time work and sports. That's another thing that we can chat about later if you want, rather than my legal work experience, because everyone's done mini pupillages generally that applies for pupillage. I'm yet to come across someone that has never done any sort of like mini pupillage or marshalling or anything like that. But it's very, well, not rare, but in some cases rare, but few and far between are the applicants that are open about all these other experiences and enriching experiences that they've done.
Thank you so much for that, Brad. I want to move on to the next question. We are running slightly behind, so I'm just going to pick up the pace here because we do have a quick fire round at the end, which I think will be lots of fun as well, because again, that will be under timed conditions. Sahar, how much weight is given to a candidate's academic performance, that's GCSE to degree level, as well as their choice of university? Does it really matter where they've studied their law degree, or is it ultimately about their performance?
I think this is something that's been touched upon several times already, so we'll try and confine the answer, but it depends on the set. As Mary's already said, if you look at some of the junior tenants in sets of chambers, you will get an idea pretty quickly about who they are looking for. If those profiles are uniquely from individuals who went to certain universities, then you're probably going to get a sense that that's what they're looking for. And bearing that in mind, it probably means if you don't fit that, it's not the best place for you to allocate one of your 20 choices. As far as the application process itself is concerned, from the perspective of those marking it, again, they've got a mark scheme in front of them, and there's only a certain number of marks that you can get, again, as Mary has said, and I don't know, I've never seen a mark scheme that gives certain marks based on the institution itself, but of course there are higher marks for better academic performance. In terms of how that is staggered, in my experience, GCSEs probably not that relevant, A-levels slightly relevant, degree and beyond more and more relevant, and that's where the bulk of the marks tend to be allocated. And that obviously includes the bar course. Academics are an important part of the job, of course they are, so they're going to form an important part of the marking process. Certain INs already, I believe, are what's known as institution blind. Certainly the pupillage scheme that we ran last time round was institution blind, so we didn't even know where candidates had been to university. I suspect as time goes on, that's going to be something that's more and more common. So try not to worry so much about the institution, because that snobbery is something that will come to pass in the fullness of time. But that doesn't detract from the point that I made at the beginning, and it's not contradictory either. You need to be aware of the places that you're applying to and what they value in as far as you can.
Thank you so much. Any thoughts on that, Mary, as well, please?
Any chambers worth their salt redacts your name, redacts the institution that you obtained your degree at, and redacts anything else which would provide conscious or subconscious bias in the application process. That is what we do at grazing in scholarship applications when the sift is done, and it is certainly what we do in our chambers and in any progressive set, because that is the best, and really it seems to me the only way that you can have candidates of the highest caliber. There is also a box on the form always which says, is there anything else you want to tell us about? And if you want to, you can add in, first in my family to go to university, state school educated, single parent, benefits, caring obligations, any form of disability or any form of adversity. That box is there for a reason. And the reason that box is there is if your academic qualifications are not of the very highest, you can gain marks in that box, which will put your academic qualification mark back up where it should be. I think that what Sahar said is absolutely right. There is no point wasting your application on a set of chambers that is not interested in someone like you. That, I think, will, with a lot of work from people like the people on this panel, change in time to come as we continue to be visible. But I can certainly reassure you that there are many, many sets which are only interested in the quality of the degree that you've got rather than the institution that you got it in.
Thank you so much, Mary. Mary, I have a question for you. Sorry, I'm coming back to you again. Probably a related question to the one that we've already had. If someone has poor academic performance, can it be offset by professional work, hobbies, or achievements in other fields or any other experience?
Sometimes. Sometimes is the answer. If you have a 2-2 and it is a 2-2 that you've obtained in the last few years, unless you have very, very strong mitigating circumstances or adversity, you may well struggle to get pupillage. It doesn't mean it's impossible, but you may well struggle. If you have a 2-1 and you should have got a first, for example, but there have been difficulties in the course of your degree, then I think you would very easily do it. But we have given scholarships to people with 2-2s, and we have given pupillage in the past to people with 2-2s. But you would need to show that there is a good reason why academically you were where you were. That is not necessarily the case for those who have come to the profession late in life or those who have transferred from another profession. Because your professional work and the skills that you have may well make the balance as it should be. I don't think your poor academic performance can be offset by hobbies, and I don't think it can be offset by other work whilst you're doing your degree. Those are the things that would go into your adversity box. But there are many, many people who've got a 2-1 who've worked 1 or 2 jobs during the course of their degree. And so if you have really poor academic performance, it may be worth you doing some other form of qualification. I'm not sure what the minimum standard is to get on the BPTC nowadays, but I think it's possible, but not probable.
Thank you.
I'd just take that on a slight tangent for a second in endorsing everything that Mary says, which I think is right. The 2-2 is not a death sentence by any means, but it does make it a lot harder. It is the point at which you need to just think about the possibility of alternative routes. There are alternative routes to the bar. I have a colleague who didn't go to university, who didn't do the bar course, who is a barrister. In fact, he's also an assistant coroner. So it is possible to do these things, but he took a different route. He went from Silex to solicitor advocate, and then to the bar. That's not something that many people do, but there are alternative routes, and it's increasingly common for people to find other ways. I'm not suggesting that, it's something that you're immediately wanting to consider, especially if the majority of you are on the bar course, but it's just something to be aware of, which is, as I say, slightly tangential to what Mary was saying.
Thank you so much for that, Sahar. Brad, should gaps in CVs be explained? For example, if someone has had to take a year out due to a personal reason, whether that's having children or getting married or any other reason as such.
I think that if it's possible to explain that gap, and if, hand on heart, you feel like that gap needs explaining, absolutely. And I know that there are varying opinions here, because I remember someone telling me that any sort of gap in your CV needs to be covered and explained. And I remember getting the exact opposite advice, which was just focus on the important things. And if there's a 1 year period where you obviously had a child or something like that, let them ask about it. And I say that because I know that some applications just don't have room for it. Some of the applications that I did 2 years ago, it was a 1 or 2 page CV and a 1-page cover letter. Don't feel like you have to go into your, however many months parental leave, or you have to go into your sort of 1 year gap year between school and university, or something like that, whatever it is, when you can be talking about the really important things that are going to get you that interview in the first place. I think it was said earlier by Sahar, focus on the positives, not the negatives. Focus on why they should be giving you pupillage, rather than what needs to be explained for or adjusted for. But I say that with the huge caveat that it is, if there's something, like I said, hand on heart, that you feel like needs explaining, then it's really important to get that down, because they can't, the interviewers, the pupillage panel, whatever it is, can't give a proper assessment of your achievements and where you are if they don't understand your context. And that's what's so important. It's about, does me explaining that 1 year, half year, 2 year gap give context to my application?
Thank you so much for that, Brad. Mary, I have an anonymous question that's come through. And he has urged that I do ask you this, please, if you would answer this. It's just in relation to a criminal record and now wanting to pursue a career as a barrister. And how would that be perceived by A, Inns of Courts, and B, Chambers?
I think the first thing you would need to do is to write to the Bar Council and to ask them whether they would take the view that you would be able to practice with whatever that criminal conviction is. Because there is little point setting out on this journey without knowing that. Lots of people, particularly those from disadvantaged backgrounds, when they are between the ages of about 13 and 20, are more likely to come across the criminal justice system than many others from a privileged background. And so it would, of course, all depend on the circumstances and the offence itself. But if the Bar Council took the view that you could practice, I would suspect that the simple thing to do is to be open and honest about the conviction itself at the outset, explain how your life has changed since then. If the Bar Council took the view that you could work as a member of the bar and you had that in writing, then I don't think of itself it should be a bar for any set of chambers or anyone else. People are entitled, of course, to make mistakes, but the rules for a member of the bar are really rather strict. And so you would need to be sure that you can practice at the end of the process. I do know, and I've spoken to a couple of people at university at the moment who had criminal convictions, who wrote to the Bar Council and were told that their conviction itself wasn't a bar because of the particular circumstances of it. So I think the thing to do is to be honest and open and find out the answers. Would it of itself prevent me from giving someone an opportunity? No.
Thank you so much for that, Mary. Sahar, we're now going to move on to a question about how to address mitigating circumstances. So how do you answer questions relating to mitigating circumstances? And would you please give us an example scenario and how that should be approached? Thank you.
Well, first up, I'll just say that this question is the reason we're actually here, because I did a post on this subject a few weeks ago. And in response to that, Mary suggested that we actually have a session, and that's kind of the genesis, obviously with Fareen's extraordinary hard work. That's where we've ended up tonight. There will be differing views on this, but I can only tell you my understanding and experience of it is as follows. Extenuating circumstances, mitigating circumstances, whatever you wish to call them, they are highly subjective, and they vary a great deal. In some instances now, I sometimes read applications and feel like the applicant has just felt compelled to fill the box because it's a box and they want to put it in. But what people say varies so much. I've seen people cite the breakup of a 3-month relationship 2 months before exams as being a reason why they got a 2-2. And I've seen people cite the death of a family member, a particularly close family member, just before their final exams to explain why they got a high 2-1. Now, those things are completely different. And as I say, there's a degree of subjectivity in this, which it's hard to take out of those examples. The panel and the individuals marking your script, almost like a jury, have life experience as well. And they have to use their common sense in determining to what extent they think that is an explanation. Now, if I apply that to an actual scenario, I won't give an illustration because I think I've already touched on the range that's potentially available. But my advice when you approach extenuating circumstances or mitigating circumstances is first to be clear on what happened so that there's no ambiguity. If it's a death, if it's a health scare, whatever it was, make sure that it's clear what you're saying happened. Secondly, explain what it impacted. Are you suggesting it impacted your A-levels alone? Are you suggesting it impacted your A-levels and your degree, or your degree alone, etc.? Be clear on what you're saying it impacted. And finally, this is for me probably the most important point. You need to make clear that the instance you're discussing is an anomaly. For mitigating circumstances to make sense, to my mind, you're trying to explain why something which otherwise may look like poor performance on your part is explicable. if it doesn't sit as an anomaly in the wider pattern of your attainment, your academic attainment, then it's not an anomaly. It's in fact just indicating your level of performance across academic study. And that mitigating circumstance won't serve to explain your overall performance across a 10-year period, unless you actually are contending seriously that it was something so serious that it impacted you the whole way through your studies. So I think you have to be careful with it, but you have to be clear as well. I'm not for a moment seeking to dissuade anyone from putting in something that they feel explains an issue in their attainment or an issue that has prevented them from doing something. But you've got to be clear about what you're saying, and you've got to show how it has impacted you. And just remember that final point, that whoever's reading it needs to look at it and say, okay, and this is just, I'm giving a deliberately almost provocative answer for the sake of illustration now. I need to be able to look at that and say, okay, well, she got 10 A stars at GCSE, 5 A's at A level, and then a 2-2 at degree. And she's saying that in the degree XYZ happened. And then she's got a very competent on the bar course. That's a clear anomaly that sits within your explanation. So that's the example I'd give.
Thank you so much for that, Sahar. And Brad, final question for you then, please. What should be included in the last question or the box where it says, is there anything else you would like us to know in the pupillage application form?
Well, I mean, I don't want to echo what's just been said, because sometimes that box features as a roundabout way of saying indirectly, have you got mitigating or extenuating circumstances? Sometimes it's included so that you don't have to sort of toil with, well, is this extenuating? And it's just to allow you to explain something, give context, as we've been talking about. And yes, I couldn't agree more with the advice that you've just been given as to that stage process of thinking, like, one, is it actually, have I actually underachieved? And two, does my explanation for my context, does that explain that underachieving? But aside from that, if you're not going to use that box for extenuating or mitigating circumstances, then that is your opportunity to put in experiences that don't fit nicely in other areas of the application form. So, and I went back, when I saw this question, I went back and I had a look at some of my applications because I couldn't remember what I'd said. And then I saw my QEB application where there was this box. And I talked about some voluntary work that I'd done. I talked about my musical interests and the instruments that I play. And I talked about my sporting achievements. Why? Because they just didn't fit nicely into any of the preceding boxes. But I thought that they were they were achievements that I am very proud of and were at the time. And they are things that give sort of more of a, well, explain more my character, my interests, what I do outside of study. So I thought it's important to put them in. And so, yeah, that box is your kind of golden ticket to put in everything that you, it's almost ask yourself, like, what do I wish I'd been asked in this application? And then answer it there.
Thank you so much for that, Brad. Now we're going to move on to our quick fire round, which will be in the timed conditions. So you will each have a minute to answer the questions. Dare I say that? And I will have a stopwatch next to me as well. Brad, most difficult part about being a pupil?
It is definitely, so I can answer this in less than a minute. It is constantly being sort of on edge. You're fully aware that this is a two-way interview, but you're also, as part of that, being interviewed for a year. So you have these moments where you just constantly think, why did I just say that? Or should not have said that. And it's small stuff sometimes, like you'll ask someone if, do you want can I get you a cup of tea or something like that when they're mid-work, and then they're flustered, sort of, no thank you, and you think, should not have said that. So, but absolutely fine. Most people, I promise you, will not even remember things like that. But you just worry yourself because you're aware that it's a year-long or even 18-month interview.
Thank you. Sahar, what is the best approach when answering competency-based questions? Sorry, Sahar, you're on mute.
It had to be said at some point this evening, didn't it? I think the answer is really to relax. If it's really basic knowledge about the practice area, then frankly, you should have it already. But competency-based questions, of course, the right answer is ideal, but what they're really looking at, what a panel is generally assessing, is your thought process and your ability to withstand scrutiny. The wrong answer isn't necessarily going to be fatal as long as you can show a lucid and coherent thought process and you can express it and defend it. That's what's really being tested, because that's also going to be your job if you're successful.
Thank you so much, Sahar. Mary, what would be your top tips on how to improve interview technique? Maybe if you would give us your best tip.
Practice the obvious questions. Why do you want to be a barrister? Why do you want to come here? Why are you interested in this area of law? Practice, practice, practice them again and again until you have those off pat. You know you're going to be asked those questions. In respect of every other question, this is all you need to do. Listen to the question and answer the question.
Wow, that was under 1 minute. Thank you, Mary. Brad, one piece of advice you would have liked to have known when applying for pupillage?
That it's a very general piece of advice. It's that it is a job interview. All of this, the bar, everything else, the ins, etc. I think all the jargon feeds into the mystification of pupillage, the name pupillage itself. You need to just remember it's a job interview, and it is like any other competitive graduate job interview. Treat it seriously. If you want it, put the prep in, put the practice in, speak to people, get people to proofread your applications and stuff. But walk in there and remember, it is not this mysterious, ancient thing. It is a job interview.
Thank you. Sahar, what tips do you have to make one's personality shine through in their applications?
It's everything Brad has just said. You've got to, again, I've already used the word, but relax and understand. People have a fixation with the bar as a concept and they put it on a pedestal, which means that when they approach an interview, they think they need to sound like a barrister. They need to talk like a barrister. They need to use the words that barristers use. That's the nonsense. And that's when you stop being able to deliver in front of the panel your personality and show who you are. So if you relax and you recognize that it is a job interview, as Brad said, then you're giving yourself the opportunity to let your natural personality shine through.
Thank you so much. Mary, what advice would you give to a considerably older candidate who wishes to practice as a barrister? Are they likely to be in an adverse position when chambers decide whether or not to invest in them?
If you have less than 15 years worth of working life, and remember most barristers work until they're about 70 for a variety of reasons, then you may well have to explain why you're going to hit the floor running. Otherwise, be proud of the skills that you have, own them, explain how they're going to help you. But the other thing that you have to do, and this is where candidates fall down, is to make sure that you understand, or at least tell them that you understand that you are learning this as a new skill. You're going to be a beginner. You will be humble enough to be a beginner, flexible enough to be a beginner, and active enough to be a beginner.
Thank you so much, Mary. Brad, what is the workplace culture like for a pupil at the beginning of their training?
It's difficult to say because I am a pupil in COVID, so I'm acutely aware that my pupillage experience is actually vastly different to what a lot of people normally go through in pupillage. I think I've met 20 members of chambers out of the 72 of us, 72 in my chambers. So I'm not kind of fully prepared to answer that question. But what I will say is that it varies vastly between chambers, your experience as a pupil. I can talk about my experience at QEB, but that might only be relevant to one of you potentially going forward. And that this harks back to what Mary was talking about earlier. Do your research as to what a chamber's like. Look at its diversity, its makeup. Look at what side is it usually for in its practice areas. Is it for the police or for the aggrieved party? Is it for the prosecution, for the defence? And by that, by looking at that and by creating some sort of resource, you can kind of deduce what the culture is going to be like when you are a pupil. And that on top of doing mini pupils and speaking to pupils, as has been said.
Thank you. Sahar, should the mini pupilages we obtain be in a wide range of legal areas or in specific areas of law?
Yeah, I think you should focus primarily on the area that you're looking to go into. But if you were applying for, say, a commercial pupillage, I would expect you to have done maybe 3 or 4 commercial mini pupillages, and then at least 1 or 2 in another area, whether that's family or crime or general civil. It doesn't really matter. But if you haven't done that, you're leaving yourself open to a suggestion that you can't possibly know you want to specialize in commercial because you've not seen anything else. And that applies, you can supplant the words commercial for criminal or anything. You need to have a look around, not just for that question, but also for yourself. Just give yourself an opportunity to see what else is available so that you're clear on the direction that you're heading in.
Thank you so much. Mary, is it worth applying in your final year at sets that recruit 1 year in advance? And I think I take that to mean final year of LLB law.
You can apply. There's no reason why you shouldn't apply. The difficulty you have is that there is a marking structure, and you will have to have a predicted grade for your degree at that stage. If that predicted grade is not quite what you're going to expect, you'll understand the difficulty that that can arise at. You will be competing with people who have completed their degree, of course, but it does happen that people get that qualification. It's good experience at filling in the forms. It's good experience if you get it at interviewing. So you might want to treat it as a possibility rather than a probability. But certainly some people do get pupillage at that stage.
Thank you so much, Mary. Brad, what is the hardest part about being at the bar and why?
I mean, as I say, I've been a pupil for 3 months now, so I'm coming to terms with it still. But there is a unpredictability or lack of routine to, I think, a career at the bar, especially the independent bar. And that's something you want to bear in mind when you're applying. There is a lot of times, at least in my set and in my pupillage, I don't know sometimes whether I'm going to be busy in the evening, whether I'm going to have to turn a piece of work around or on the weekend. Sometimes it's sort of something comes up last minute. My supervisor says, can you please just sort through this for me or something like that. So that's something to bear in mind. And that's one thing. And I say the second thing is work taking 3 times longer than what you think it's going to be at the outset. You look at something and think an hour, or definitely then double it at least.
Can I just say on that point, thank you so much for joining us this evening, then. You've dedicated a lot of time to us. So, Sahar, should you put down experiences in the gateway form, such as moots, advocacy competitions, where you did not progress very far, to show that you have taken part and learned from it?
Yeah, up to a point. If you've done 10 mooting competitions and you've never progressed beyond the first round, I wouldn't lead with that. But I think you can probably indicate that you have some mooting experience and cite 3 or 4 of them.
Thank you. Mary, what is the value of an LLM in pupillage application forms?
This is a very difficult question. I think a lot of people do an LLM because they get the opportunity to have funding for the BPTC. But again, there is a maximum amount of points for academic achievements. If your degree is not at the highest level and you've done an LLM, that will probably bring it up a little bit. But if you've got a first class honours degree and an outstanding on the BPTC, the LLM in itself won't particularly matter. It may matter in some sets if you have done your degree at a non-traditional university or non-Russell Group university, and you've done your LLM at a Russell Group university. But the key is the grade in your degree and the grade on your BPTC.
Thank you. Brad, how many application forms would you recommend we submit during the pupillage application cycle?
This is the age-old "how long is a piece of string" conundrum. There may be too few. It's possible to do too few. Maybe 3 is too few. I'm not sure. Maybe 25 is too many. But you know, the in between is what you think you can properly commit to and make your application strong. That said, I know someone that did 1 application and got the pupillage. So for example, if it helps, I'll give my own example. I think I did 12 applications for pupillage, and I got it in 1 year. So I made 12 applications. I think it was 8 first rounds and 5 or 6 second rounds. So that's something to bear in mind. And you need to remember that the quality of the application will diminish with the number of applications that you do. So don't overstretch yourself, especially if you're doing it alongside the bar course or alongside full-time work.
Thank you. And finally, Sahar, what challenges do you think future pupils will face, and will BSB make concessions for the year that we've lost due to the pandemic?
In relation to the concessions, yes, of course, but those will be uniform because the impact has also been uniform. So don't think you'll get special treatment because of COVID. I suppose unless you personally have suffered specific and direct loss as a result, which you'll be flagging in the way that we've discussed before. Sorry, I've forgotten the first part of the question now.
Sorry. So it is, my apologies, Sahar. So what challenges do you think future pupils will face?
I don't see those particular challenges as changing dramatically at the moment. The challenge that pupils face, Brad has already alluded to. Being a pupil during COVID has been extremely difficult. Not having that opportunity to physically be in chambers, to sit in a room, to learn not just from your supervisor, but those around you, to hear conversations, to see what goes on in the clerk's room, that's tough. And I feel for current pupils. But beyond that, the challenges remain the same.
Thank you so much for that. And that brings us to an end. Can I ask you all in turn to just, if you'd like to make any closing comments? I'll start with you, Mary, please.
Try to think of pupillage applications and scholarship applications like any other application. We know what you've got in terms of your academic ability and your background. What we want to know is, who are you? What sort of person are you? Are we going to enjoy working with you, not just for this year, but for the rest of your practice? So let the panel get to meet you. Don't try to be somebody else. Be you, always. There is absolutely no one better.
Thank you. Sahar, please. Would you have any closing comments?
Yeah, just at the end of all of these events, I'm always saying the same thing, which is answer the question. You're doing the application form now. I cannot tell you how infuriating it is when you mark these things for someone to just dance around the question and not answer it. If you're successful in becoming a barrister, I promise you during the course of your career, more than once, you will hear somebody say to you, it's your application. That is something that you will hear from judges especially, but this is your application now. And in the same way that if you don't answer a question when a judge poses it to you, you will piss them off. You will piss off the people marking your script if you don't answer the question. So please answer the question. Focus on that. Go back and read it when you've done it. It's simple things as well. If the question says, what will make you a good barrister? The word good is in there for a reason. You need to address that, not just what will make you a barrister. People omit that word and it changes the answer. So focus on the question and make sure you answer it.
Thank you so much, Sahar. Brad, please, if you have any closing comments.
I would just say to sell yourself. Don't embellish, but sell yourself. You are the expert of yourself. You are the only expert in the world in yourself. You know what your achievements are. You know what you've done well in life. You know what makes you shine. And don't be afraid to put that down on paper and put it down in a way that's going to sell yourself best for pupillage. And have others look at your application wherever possible and ask them, what makes me sell? What makes me shine in this application? And take their feedback on board.
Thank you so much. Thank you very much indeed to you all for joining us this evening. Thank you so much for the time that you've dedicated and the really valuable advice and tips and hints that you've shared today. Please, may I make a request? Can I take a picture of us all, if that's okay, please, so I could share it on social media. I'd also like to say to all the participants, if you will also please send in some feedback about the event today, things that you would have perhaps wanted to have been done differently, or any suggestions that we might be able to incorporate in the future. Do please, if you have some time after this event, go online and share with your connections on LinkedIn or on other social media accounts about the experience that you've had today, courtesy of Law Simplified and aspiring barristers. So I'm just going to take this picture if I can. Yes, we have everyone in there, and just making sure we don't have any closed eyes. No. Very good. Thank you so much for that. So I do want to, as I've mentioned, please do follow Law Simplified. We are on all the social media accounts, and it'd be really helpful if you would send in some feedback so that in the future, once we do arrange more events, just like the one that we've had today, we are able to do things and implement your views. And on that note, all the very best to every single one of you who is applying for Pupillage, which commences this upcoming Monday, and Happy New Year. Thank you.
Well done, Fareen. Thank you so much for organising it. Thanks, everyone.
Thank you.
Thanks, Mary. Thanks, Brad.
Thank you all. Thank you.
Well done, Fareen.
Thank you so much, Mary. Thank you.